today's presentation on the top patent law stories of 2024. So here's a list of what we're going to be talking about. I'm going to touch on what we might see in the U.S. patent system coming out of the second Trump administration. Then Kevin is going to address some FTC initiatives, obviousness type double patenting, and the situation with Judge Noonan. And then Mike is going to close with a few USPTO topics on the fees, Patent Center. He has a lot of nice stuff to say about Patent Center, and on artificial intelligence guidance coming out of the office. So let's kick things off with how the second Trump administration may impact the U.S. patent system. So it has had an immediate impact in that, as is typical, we have a new acting director who took place in office on January 20th, Inauguration Day, last week. So the acting director is Coke Morgan Stewart. She's been at the Patent Office previously, has bridged a few different administrations. So she was there from 2011 to 2021 and has served under a number of positions, which are listed there. Prior to rejoining the USPTO last week, she was practicing at O'Melveny and Myers. And prior to being at O'Melveny, after leaving the Patent Office in 2021, she was the Deputy Attorney General for the Commonwealth of Virginia. In private practice, she's handled 70 Federal Circuit appeals, and she's a graduate of Duke and University of Virginia and has clerked on the U.S. Court of Claims. So one thing that Acting Director Stewart had provided was an article last August about what we would see if Donald Trump was elected to a second term. And so she gave us a list of things that we might expect to see. So revoking or reversing the WTO waiver that we've talked about in previous Top Stories webinars, and not using march-in rights, which the Biden administration had talked about doing but didn't end up doing. She also says that we could expect that the Trump administration would be skeptical of efforts by larger companies to strengthen post-grant proceedings, and that the Trump administration would be most sympathetic to startups, small businesses, and independent inventors. The Trump administration, in Acting Director Stewart's opinion, would also be likely to support some of the bipartisan IP reform efforts that have come out of the Senate Judiciary Committee, and we're familiar with those, and I think some of those have been part of our previous Top Stories webinars. Not a surprise, but the USPTO director, whoever that's going to be, is unlikely to be someone who will be putting policy agenda ahead of what the Trump administration would want to do. The Trump administration, like the Biden administration, is not going to allow China to continue to try to steal IP and sell us counterfeit goods. And in Acting Director Stewart's opinion, the Trump administration is likely to believe that a patent system is good for economic prosperity, and that the administration would stick by the 2024 Republican platform promise to champion innovation. So who will the next director be? The only name that I found online was Vishal Amin. That's from our friend Gene Quinn at IP Watchdog, and he proposed that in December. Earlier this month, he had pulled off of that, so his sources are telling him that it's not going to be Vishal Amin. I left him on here because he previously was the IP czar from 2017, 2021 under the first Trump administration. He's now the head of intellectual property at Intel. And I've put Acting Director Stewart on here, given her ability to cross administrations, and obviously the Trump administration thought enough of the acting director to make her acting director. When would we expect to see the next director? Well, You may have watched confirmation hearings last week and yesterday with RFK Jr. There are some positions that are a little bit more important that I know it's hard to believe for us patent practitioners and applicants that there's something more important than the USPTO director, but there are, and it's not unusual to have to wait several months into a new administration to get a permanent director. And so we can look at the three members who came in as directors with a change of administration, Director Kapos, Director Yanku, and Director Vidal. And there it was August, February, and April. I don't think we're going to be seeing a new director in February. I could be wrong. So I would say March to August would be the time frame when we could expect to see the next director. One other thing that a lot of people are probably aware of is that President Trump issued a large number of executive actions and presidential orders and proclamations as soon as he got into office. And I'm going to talk about 9 of them that were issued last week that might have an impact on the Patent Office. And we've already received a little bit of information to show that this first one, return to in-person work, might not be as bad as one might think. So the return to in-person work action terminates remote work for all departments and requires employees to return full-time at their respective duty stations. And more on that on the next slide. But before that, let's talk about the regulatory freeze. So we're probably not going to see any new regulations coming out for a few months, probably not until we have a permanent director. But this action says that no regulatory review, no rules can be issued until the permanent department or agency head has been appointed. So we have to wait a little bit. So on that return to in-person work, the Office of Personnel Management on January 22nd last week issued some guidance on this particular presidential memorandum, and it required agency heads to take the following actions by last Friday, 5 p.m. Eastern time last Friday. 1, to revise their telework policies to require that all eligible employees return to their duty stations full time, and to notify all employees in the department or agency by email of the presidential memo. One last requirement was to notify the OPM of when they would be able to fully comply with this particular memorandum. So things looked like the Patent Office, which relies a lot on remote and telework, and has, as you may have heard, gotten rid of a lot of space in Alexandria in its large complex because it didn't need that space anymore. It looked like this might be a problem. On Friday, as complying with that OPM memo, the Department of Commerce issued a memo, and it rescinded the 2021 telework remote plan for the Department of Commerce. It eliminated regular and recurring telework and remote work, and it required all employees to come back to their duty stations, except for it exempted USPTO employees, and as well as employees from the Office of Inspector General, and then this last one, this last group. So it doesn't look like that a presidential memo is going to have an impact on the USPTO. One that will likely have impact is the hiring freeze. And so, as you may have heard, the prior administration was in the process of hiring hundreds of new examiners to help with pendency issues. And all of those hirings have been frozen now. And the memo requires department and agency heads to try to seek more efficient use of their existing personnel. So we'll have to see if this hiring freeze continues to bear out and whether the USPTO is stuck with the number of examiners that it currently has. One other executive action that you may have heard about was the U.S. withdrawing from the World Health Organization. And this is not the first time that this has happened. I guess I had forgotten that back in 2020, the first Trump administration had withdrawn from the World Health Organization due to the administration's feeling that the organization had mishandled the COVID-19 pandemic, and also was allowing certain WHO members to have what the administration thought was inappropriate political influence over the organization. The memo that just got issued noticed or put everyone on notice that the U.S. intends to withdraw from WHO again. It revoked the Biden administration's letter that retracted the first notification, and it also revoked a Biden executive order that was related to combating COVID-19. Another thing you may have heard about is this DOGE, Department of Government Efficiency. So we have a action or order that establishes this new department to help modernize federal technology and software and maximize governmental efficiency and productivity. Of interest to the USPTO is that all agency heads have to create a 4-team DOGE team, a 4-member DOGE team, and that DOGE team will advise agency heads on implementation of the DOGE agenda, what that is when it's more fully developed. In addition, there was a action order on DEI programs, and so this order requires all agencies and departments to terminate all discriminatory programs, including, and I'm quoting, including illegal DEI and diversity, equity, inclusion, and accessibility mandates, policies, programs, preferences, and activities in the federal government. And in addition, the order required all department, agency, commission heads to get rid of any positions that are related to such initiatives, and also submit to OMB a list of all positions, committees, programs, services, activities, budgets, and expenditures in existence as of November 4th that were related to DEI, DEIA, or environmental justice programs. And then this little part at the end, also including that list, any programs that have been, according to the order, misleadingly relabeled to preserve their pre-November 4th status. We have another similar type order that seeks to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements at all departments and agencies. And I thought what was interesting here was that it orders agencies to, and again, this is the words of the action, combat illegal private sector DEI preferences, mandates, policies, programs, and activities, and to kind of, according to the order, take appropriate action to advance a policy of individual initiative, excellence, and hard work in the private sector. So it's not just federal departments and agencies that order seeks to impact. One more order we have on our artificial intelligence, and that the main thing I think about this order is that it requires a preparation of an action plan within 180 days to achieve the policies, the AI policies set forth in this order. And the last one that I wanted to talk about is the PCAST, President's Council of Advisors on Science and Technology, which will be no more than 24 members from academia, industry, and government to help with the policies and objectives that are in that first bullet point, including a focus on harnessing the full power of American innovation. So that could be good news for the USPTO and for applicants seeking patents. The last thing I want to talk about in my part of the presentation is something that was very controversial and talked about a lot, at least what I was watching and reading, and that is Project 2025. So Project 2025 is the 9th edition of a series of books put out by the Heritage Foundation. The series is entitled Mandate for Leadership, and so this is technically Mandate for Leadership, and then has as a subtitle on the next page of the book, Project 25 listed. And these were put out by the Heritage Foundation right before elections to offer conservative policy recommendations to be implemented if the Republican candidate had been elected. And so the first one came out in 1981 for the incoming Reagan administration. And this one was published, Project 2025 was published in April 23 in the event that Donald Trump was reelected. So there was a lot of Trump campaign information coming out that they weren't, that Project 2025 is not a Trump campaign platform, but the campaign itself acknowledged that they had regular contact with the Project 2025 contributors, many of whom were in the first Trump administration as well, and that the project aligned with the policy objectives of the Trump campaign, which was Agenda 47. I went and looked at Agenda 47 on the Trump campaign website and didn't see a lot of stuff, not surprisingly, on the Patent Office. But the Mandate for Leadership Project 2025 does have some good information in it about the Patent Office. So it's Project 2025 is, as you may have heard, over 900 pages long. One chapter, Chapter 21, is on the Department of Commerce. And in that first bullet point, which I'll let you take a look at your leisure when we send the presentation out, the objective, at least with respect to IP protection, is that this is important for the U.S. economy, and so that's good news. They had some ideas about reorganizing the USPTO, but let's get to the meat as I close up my part of the presentation. There's one page in Project 2025 on just the USPTO. And regardless of your political leaning, if you're a patent practitioner or you're a patent applicant, you probably wouldn't have too much, you wouldn't take issue with any of the proposals that are on at least that page of Project 2025. And I've listed them here. The second point is to re-examine patent eligibility requirements under Section 101. So I think we've in the community been clamoring for that for years. To take a balanced approach, which is not defined or explained in the Project 2025 part on the USPTO recommendations with respect to the PTAB, and then also to oppose efforts to institute IP waivers through the WTO and TRIPS. And then I've got a couple other points here, but I want to move on and get to the next section so you can take a look at this at your own leisure. One last thing. So that second bullet point is the price negotiation, and so the recommendation is to get rid of that. And there has been talk that the Trump administration will do that, get rid of the price negotiation, drug price negotiation. So we'll move on to Kevin.
So the first slide is just essentially a reminder And I think it's an important reminder of FTC and what FTC can and has done when they get sort of the bit in their mouth that there's something that patenting is doing a bad thing to consumers. I mean, as you know, the FTC under the Clayton Act was formed so you could actually have a government agency, which interestingly, there was a footnote in a recent opinion that reminded us that the FTC is not part of the executive branch. It's a separate commission. So even though they're certainly influenced by what the administration wants, they're not sort of controlled by whoever happens to be president, and that can be either good news or bad news. What this reminds us is that in the early 2000s, that the FTC got in their head that what some people would call reverse payment settlement agreements and litigation, that FTC always called pay for delay, was harming consumers because it kept generics from getting on the market. And it took them a while, but eventually they got a Supreme Court case where the Justice Breyer wrote an opinion, majority opinion, in which he said, well, we're not going to agree with you, FTC, that these are per se illegal under the Sherman Antitrust Act, but we're saying that we're going to scrutinize under the rule of reason. So sort of a very sort of midway position. What it really did was provide a way for certain costs, like avoided litigation costs, to be used as a way that parties could settle. And what happened many times is that a magistrate judge was sort of designated by the district court judge, and before whom and a litigation was proceeding, and they would be part of the negotiation and essentially arbitrate what a fair number would be, which gave at least a judicial patina of not being some sort of an abuse. So that's where we were. Next slide, Don. But recently, and you probably are aware of now former, I think, Chairperson Lena Khan was much more aggressive. She wrote a law review article 8 years ago now, when she was at Yale, that created quite a stir. And she has spent a lot of time opposing mergers and that sort of thing. But sort of halfway through or so her tenure, she decided that she was going to look into pharma and Hatch-Waxman. Next slide, Don. And she basically targeted 10 companies. And the reason that she did that is she thought that, or FTC took the position, that there was a problem with Orange Book listed patents that were directed toward devices. Now, I'm sure people, there's a lot of drugs now, whether it's insulin or Ozempic or whatever they are, this idea that you would have some sort of a device, the EpiPen, for example, that would enable you to sort of routinely and reliably give a certain dosage of a drug, or tell you how much of the drug you had left, so that you would not run out. The FTC decided that really wasn't right, that you shouldn't have Orange Book listed patents on these devices, because if you look at the way the statute is written, it's about drugs and methods of administering or using those drugs. And the argument was, well, this really isn't a drug or a method of using per se. The most pithy way of putting it was, in Mark Lemley wrote an amicus brief in a case we'll talk about in a minute, where he said it's kind of like if you invented cough medicine and got a patent on a spoon. And I'll tell you that I think really resonates with a lot of people, and you can understand, next slide, Don, why that would be a problem for them. What it ignores, Don, next slide. What it ignores is the fact that, a spoon is a spoon. But the benefits, if you've ever tried to administer a drug to anybody, is that there's a certain amount of inaccuracy in doing that, and at least properly calibrated, that doesn't happen. And there are other sort of benefits of that as well, ease and that sort of thing. This just shows you the companies. This just shows you the companies that were targeted, and how many patents they had, and how many new drug applications they had gotten granted. And you can see that the bottom two, Teva and Novo, were the ones that had a great many patents and very few NDAs in comparison. Next slide. So this actually came to a head in a district court case, Teva versus Amneal, where the district court ordered that the Teva delist 5 of its patents for its ProAir HFA inhalation product. The interesting thing, and nobody was shy about it, was that FTC filed an amicus brief that the district court decision, the judge, extensively quoted from. And I'm not saying FTC wrote the decision; they certainly didn't, but extensively quoted from and used as the basis and the rationale for that. And the court said, look, under 21 U.S.C. 355, et cetera, that enables you to claim a drug product. This isn't a drug product. There were two other cases in the First and Second Circuit, and a little type down there tells you where to find them, that talk about this, right? And the other thing that I think was important in this is that Teva only asserted that its Orange Book listing was proper under the drug part of the statute and not the methods of administration. And I understand why Teva wanted to get this device patents that could be used with many kinds of drugs, but there wasn't a claim that had the albuterol sulfate as part of the claim with the device. And so that was another way it sort of made it easy for that to happen. Don, next slide. And this went before the Federal Circuit, which unfortunately that should say Federal Circuit, but doesn't, that affirmed. It was Judges Prost, Toronto, and Hughes, and they really did a deep dive into the statutory language, right? And according to them, they said it had to claim the drug for which the applicant submitted the application. The other thing that the court was interested in, and this was a little bit of the interest in the district court, but I think the Federal Circuit sort of really honed in on it, was that there was actually an attractiveness, that there'd be a motivation. I mean, courts are very, very worried about shenanigans. And there was an attractiveness to use this Orange Book listing because it gives you a 30-month stay before the whatever it is that you have in your NDA is approved. The FDA doesn't look for it for 30 months, which gives you the time theoretically to litigate, but also once again delays anybody else getting approval. And the FDA was no help in this regard because they've had the position for a very long time. They don't decide whether you should have an Orange Book listing properly or not. Okay. I think that there are statutes in the asterisk here, two statutes in the bottom that give the defendant the ability, as Amneal did, to assert there was improper listing. But there's no way to actually take the company to court and say these shouldn't be listed, only when you're sued. Right. And it said recently the court entered a stay, and they've now filed an en banc petition, not just an intention, they've actually filed an en banc petition because they're asking the Supreme Court to look at this, and they have their petition is incredibly vigorous about the problems that this could create. And I think that they're wise because not only is it directed to devices, but they say, wait a second, if you look at the logic that the Federal Circuit applied, it would apply to a genus claim. And so if you filed a genus claim with your NDA, that could be too overbroad and improperly listed. And there'll be a post-it on this, and you can read about that in more detail, or you can look up their petition. Anyway, so we're sort of at this place where no matter what, as Don said, what the Trump administration intends to do, FTC, I don't see any impetus for FTC to change their position. And frankly, this is now the law, that device patents per se are improperly listed in the Orange Book. And, given the fact that antitrust issues can raise criminal liability and penalties, I think there'll be a lot more with this decision, which is fairly recent. There'll be a lot more impetus for companies to delist. We'll see how that turns out. Next slide, Don. Kind of the good news, and obviously double patenting, I'm just going to remind you that at the beginning of the year, we had IMRE Select. And this is just the timeline for it. And the decision was that initially in several reexamination proceedings in the Patent Office, and then affirmed by the Federal Circuit, and the Supreme Court didn't grant cert, that it's the earliest expiration date controls. So if you look at this, you'll see there's this one case, the 036 patent, and that was the one that had no PTA, and it was the early expiration date for that reason, and it wiped out all of the PTA that these other patents had received due to Patent Office delay. So that was where we were then. Next slide. So the Federal Circuit, later in the year, in an opinion written by Judge Laurie, who wrote the opinion for IMRE Select, said, no, it's the first filed and first issued, and the later expiring claim can't be invalidated by anything else. Okay, and so there's what happened here. The first filed was the 356 patent, and it was first issued earlier than any of the other applications, and it got almost 500 days of PTA. And the fact that these other patent applications, which were filed later and granted later than the 356 patent, they had no effect on PTA. So we sort of have a problem here. Don, the next slide illustrates it, that these aren't consistent. Take my word for it. If you look at the left-hand slide, which is select, you had the 036 patent taking all of the PTA away from these cases. But if you look carefully, the 626 application, right, which was filed before the 036 application and granted before the 036 patent and had 59 days of PTA, that didn't count. It lost its PTA, as did everything else, over the 036 patent, which was the first filed, first issued. And you see that what was done on the right-hand slide is the MSA case. So we have essentially two, and it's funny because, of course, the second case should have been governed by the first case, but Judge Lurie did a good job of explaining to people why he didn't exactly say what everybody thought he'd said in the Select case, and in fact, what he meant to say was what he had said in this case. So I think we're a little up in the air. Next slide, Don. With that, in terms of the judiciary, the good news is that the PTO proposed these changes in terminal disclaimer practice that would say there would have to be an agreement, right, that the patent that had a terminal disclaimer would be enforceable, and only if the patent was not tied or had never been tied directly to a patent by one or more terminal disclaimers to obviate that any claim has been finally held to be unpatentable or invalid, where statutory claim is filed after any challenge based on anticipation obviousness. So it made this very complicated way that all of these things were sort of interchanged. Now, the problem with it was, number one, if you look at 35 U.S.C. 282A, that's the statute says that the validity of one doesn't influence the validity of another patent. You sort of judged on your own merits. And of course, Loper Bright came out, and the validity of the office interpreting, well, it's not even really a statutory interpretation, because obviously type of patenting is a judge-made rule. It does raise a few questions about that, but fortunately for everybody, the PTO dropped the proposal. So it's not a problem, it's not an issue, but it is something that was motivated by, as I understand it, the great push by many people to make drugs cost less. And there was and still probably is, a meme out there that says, oh, all these patents are part of patent thickets, and all these double patent thing, they shouldn't be able to get these patents. In fact, I think there was the proposal that you only get one patent. Maybe it was a legislative proposal, I don't remember, but you get one patent on a drug, and you can't get more than one. And I think that a lot of that's been caused by the way that the biopharm community has reacted for biologic drugs, that most of the approved biologic drugs were approved a long time ago and no longer have any regulatory exclusivity. And so, and many of even the compound patents, like Humira, expired maybe 8 years ago. And so companies that had to go to the patent dance with something had patents on methods of making and formulations and that sort of thing. And that was seen because some companies may file quite a lot of patents for that as a way that it's just evergreening and bad for the consumer. In any event, this is not going to happen. How the judiciary figures out what the right rule is will depend. But for now, unless the Supreme Court wades in, which I really doubt, for now it's pretty much what Judge Lurie said last, which is the first filed and first issued and later expiring is what controls. Next slide, Don. Okay, Judge Noonan. Next slide. So, for those of you who somehow don't know who Judge Noonan is. She's one of the longest serving judges in the federal court system. She was one of the, if you remember how the federal circuit was established in the early 80s, there was an act of Congress that established the federal circuit. And many of the judges on that first court, in fact, almost all of them, came from the Court of Claims and Patent Appeals, the old CCPA, which was the court that really was limited to patent office issues and did not have as its jurisdiction district court decisions. The federal circuit clearly does, as well as jurisdiction for a lot of other things. She was one of the first those appointed in 1984. So if you do the math, right, that's 40 years ago she was appointed. recently, I say over the last 10 years or so, she really has been what people have called the great dissenter. And one of the reasons for that is that many of the judges in the Federal Circuit at the beginning had patent experience. First, they came from the CCPA, for one, and just that was the way that Congress tended to appoint these judges, or they were able to, judge presidents did it, and they were approved by the Senate. Well, if you look at the mandate for the Federal Circuit, it's not just patents. There's lots of other things that they do, and as the court progressed, a lot of the judges didn't have that background. Judge Reyna, who's a great guy, by the way, I was at a meeting with him and talking to him, and he said, yeah, he didn't have any patent experience when he started, learning on the job. That's okay. But it meant that there's a lot of people who didn't come from that same, if you want to say, mindset. And so they didn't have technological or scientific backgrounds or work in those industries. And that was why the Federal Circuit was so good for patents in the 80s and 90s, and not so much lately. Because Judge Noonan, coming from that time, had the way that she thought about things. And when her colleagues disagreed, she dissented, which is perfectly fine. That's something that I think is necessary, and she was not shy about it. Next slide. So then this comes mostly from Judge Noonan spoke during the luncheon at the Bio IPCC committee last fall, and she'd never spoken about this publicly to my knowledge. So a lot of what comes in here comes from that. So early 2023, she wasn't included on some of the schedules of cases to be heard, and I think the reason, or at least she interpreted the reason at the time, was that she was behind in some of her writing, and so she just needed to get on top of it. But then in March, the chief judge visited her and said, "You should step down." And part of the reasons for that is that there were reports that she couldn't do it anymore, that she had a heart attack and had fainted in the hallways and was abusive toward court staff. And to hear Judge Noonan tell it, the problem is that at least none of those physical ailments and impairments had happened. She didn't have a heart attack, and she didn't fall down or faint or anything like that. So she was a little perplexed by why people were saying that. I would imagine she was less perplexed that she might have been sharp with court staff, but I think she probably doesn't suffer fools gladly, and if you're in her position, she wants things done the way she wants things done without really having to apologize for it. I'm sure plenty of judges feel the same way. Next slide. So the chief judge, who's allowed to do this, instituted what's called the special committee. It was herself, Judge Prost, and Judge Toronto, and they told Judge Noonan that she must undergo neuropsychological testing and examination by doctors. Which doctors? The committee's doctors. Judge says, well, what I'll do is I will give you my medical reports and the results of these sorts of tests from my doctor. And the committee refused that. And they were at an impasse, because they couldn't compel Judge Noonan to undergo these tests, and they were not willing to accept the tests from her judges. So they couldn't figure out whether she was impaired or not. Next slide. And then the complaint became, and it's a little Kafkaesque to my mind, but the complaint became, well, the complaint against her was judicial misconduct, because Judge Noonan had not complied with the demands that be established. And that pretty much relieved that special committee and the Judicial Council, which we'll talk about in a minute, from having to actually figure out whether there was any justification to that complaint that was lodged. That Judicial Council was all active members of the court. And as you might imagine, Judge Noonan was not on that council, because unanimously they voted to suspend her for 1 year starting in September of 2023. Next slide. The basis for all of this is the Judicial Conduct and Disability Act, and it gives federal circuit courts a way to investigate issues if there's mental or physical impairment as well as misconduct. And I haven't looked really deeply into this, but a lot of them are, issues that people had, harassment, that sort of thing. And the judge can create a special committee, which she did, that would investigate these allegations, and then the Judicial Council would make a recommendation of what they should do. And typically it's been suspensions, but it goes up to and including recommending to the House of Representatives that the judge be impeached. Also, under exceptional circumstances and at the chief judge's discretion, you can transfer that to another circuit, and Judge Noonan has asked for that to happen, and it's been denied. there's no other avenue to appeal. And the asterisk is there at the end to remind me that there was a judicial council of circuit court judges from outside the federal circuit who backed up the judicial council in the federal circuit on the suspension. Next slide. So Judge Noonan, as you might imagine, is not shy. She filed a civil suit in the District Court of D.C. saying that those actions were unconstitutional because, as an Article 3 judge, if you wanted to get rid of her, she had to be impeached, and that requiring her to submit to this testing was a violation of due process, and that the basis for the investigation had no merit, that what they were saying about her wasn't true. It went through, and the District Court dismissed all the counts, mostly on procedural grounds. And the other thing is that in order for her to prevail, she would have had to convince the court that this act was not facially, it was unconstitutional. Don's telling me I'm 2 minutes over. I'm not sure that happened. Next slide, Don. And I think I only have one more. The other thing happened is that on the anniversary date, they reinstituted the suspension and said that she was in charge of that because she could just comply. Next slide. And on the argument she makes is, as you might imagine, that the Judicial Council has usurped the Constitution. Next slide. And where we are now is that, you know, it's before the District Court, the Circuit Court, District of Columbia. And the interesting thing is there are 4 amicus briefs that were filed, one of which was by these judges, Michelle, Rader, Vashkut, Castle, and Braden, all of which said that she'd been removed from office improperly by having the suspension expanded. Next slide. And for now, she's 97 years old. And even though she said in this talk I told you about a minute ago that she hoped to be there and celebrate with us at her centenary, she knows, I think, the clock is ticking. And I think I call this an American tragedy and an unnecessary one, because here you have someone with her background who literally, people are running out the clock, and just, you know, there's only one answer to this, the way it is right now, and she'll eventually die. And I hope this gets resolved before that. So sorry for running over a little, Mike. I'll leave it up to you.
So I have 3 topics, all about the USPTO. First one, new fees. So the USPTO announced new fees last November. So technically this is a 2024 story, even though they didn't go into effect until about 11 days ago. As usual, and as expected, the PTO increased fees pretty much across the board for more or less everything. They did decrease some fees, but those are fees that I almost never see used. I've never personally used them. So these are mostly increases or majority increases, and some of these increases are significant. So we're going to talk about those. We're also going to talk about some of the new surcharges and how they can be a bit tricky in practice, and some of the gotchas for practitioners. So of interest are the new continuation surcharges. These are not the fees. These are surcharges on top of the fees. So if you file a continuation, and that includes a continuation in part and a divisional, as well as a normal continuation, if that continuation's earliest priority date is between 6 and 9 years prior to the date of filing, your large entity fee is $2,700. That is in addition to the $2,000 that you now have to pay for the filing and normal fees to get the continuation on file. There's a $2,700 surcharge. If your continuation has an earliest priority date more than 9 years prior, then the large entity fee is $4,000. So I view fees as a way of the Patent Office applying incentives to applicants. So the incentive here is pretty clear. The office does not want applicants to be filing a lot of continuations and keeping families open for long periods of time after the initial priority filing took place. And unfortunately, that is one of the more promising strategies that applicants can take, especially if they expect parallel litigation or are preparing for litigation, keeping a family open so you can craft claims around new prior art that might be cited during the litigation or an IPR. So this does make that practice quite a bit more expensive, although there are small and micro entity discounts. And also read the Federal Register notice very carefully as to what does or does not apply to this earliest priority date, because some U.S. provisionals or non-U.S. applications, if they are the earliest priority document, you may find yourself paying fees that you don't actually need to. The PTO has also increased excess claims fees. This continues a trend that's been going on probably for at least a couple decades. And each independent claim in excess of 3 has gone up 25% from $480 to $600. Not a huge increase, but each claim in excess of 20 has gone up from $100 to twice that, $200. So that is pretty significant. As for the incentives here, it seems pretty clear that the office wants applicants to file no more than 20 claims with no more than 3 independents to make the examiner's job a bit easier. Next, we have RCE fees. So the office instituted this 2-tier RCE fee policy the last time it increased fees, and now it's made the second tier significantly more expensive. So for your first RCE, it now costs $1,500. That's only a 10% increase. But for your second and any subsequent RCE, it's going to cost you $2,800. That's a 43% increase. And so the applicants are now incentivized to try to finish prosecution, especially before that second RCE, and not keep cases just open forever, filing RCEs and kind of getting nowhere. So now you really want to try to have compact prosecution, and if you can't reach an agreement with the examiner, take it to appeal before the second RCE. And finally, and perhaps most importantly, the large IDS surcharge. So I'm going to spend a little bit of time on this because it's complicated and there's been a lot of questions about it, especially over the last 2 or 3 weeks. So this is a surcharge in addition to any IDS fee you might be paying based on timing. So if you have a situation where you're filing an IDS after a non-final before a final action, normally you would have to pay a timing-based fee on that. This surcharge applies regardless. So it's in addition to the timing-based fee, but even if the timing-based fee doesn't apply, the surcharge still does. It is based on the cumulative number of references cited by the applicant, and any examiner-cited references do not count towards this threshold. So there are 3, in fact, different thresholds, each with different fees. There's a threshold you cross when you go from 50 cited documents to 51, 100 to 101, and 200 to 201. And the fees are only applicable when a threshold is crossed. So if you have a pending application right now for which, let's say, 300 IDS references have been cited, that application, as far as I can tell, will never be subject to this surcharge. However, if you have an application with 50 references cited, as soon as you cite your next reference, you will have to pay a surcharge. So the burden here is on the applicant to accurately count cited references. So this is a new thing that you have to do. There are software tools out there, IDS management tools, that help you do this. But if you don't have those, you're probably going to have to start keeping it all in a spreadsheet or some other mechanism like that. Additionally, applicants must include the proper IDS size fee assertion with each IDS, even if the fee is not due. So this is now part of the standard IDS form that the PTO has published. So you should download that if you haven't already, familiarize yourself, and it's just another set of boxes you need to check. You have to indicate that you've reviewed the number of references cited and indicate whether or not a fee is due, and if the fee is due, how much needs to be paid. As regards to the actual fees, each threshold has a different amount, $200, $500, and $800 respectively, but they are cumulative amounts. So if you have to pay the $200 IDS surcharge, and then later on for the same application, you have to pay the $500 surcharge, well, you actually only have to pay $300 of that $500 because you've already paid $200. Now, there is no small entity discount for this IDS surcharge. So this is quite a bit of a burden, in my opinion, on smaller applicants and especially universities, because university inventors are often faculty or researchers, and their inventions are often documented also parallel in papers, and those papers might cite 100 or more references. There doesn't seem to be a way to get around having to pay a surcharge in those situations, unfortunately. So the new IDS fees can be confusing. The Federal Register notice was not at all clear. There was some debate in the community when it first came out last year. And I think that if you just look at that notice, it's easy to make mistakes in both directions by paying a fee that's not required or by not paying a fee that is required. However, recently, within the last 2 weeks, the PTO published a quick reference guide just on the IDS size fees, and it runs through a number of scenarios and examples. And I think that the quick reference guide is actually a pretty good document. I found it to be very clearly written, and the examples are rich and detailed enough that it covers just about any scenario that you might come across. So I would say read the Federal Register notice, but really focus on the quick reference guide. Okay, next topic, Patent Center. Let me just start by showing you this. If you have not seen the 401 error code from Patent Center, you haven't been using Patent Center. It is rare that a day goes by that I don't see this. Sometimes I see it half a dozen or more times. It is indicative of what has become a major problem over the course of 2024. The USPTO has one portal that practitioners, applicants can use to file applications, file papers in pending applications, and view the status of applications. That one portal is Patent Center, and it ain't working very good. So it was established back in late 2023 to replace the electronic filing system and the PAIR system. Both of those systems, well, neither one was perfect, but for the most part, they work pretty well. Patent Center, on the other hand, started off kind of okay. It was missing some features, even though the PTO said that it wasn't. And over the course of last year, it has experienced an increasing number of issues, mainly unavailability and slowness. There has been, as far as I know, no admission from the PTO that they have a problem on their hands and no timeline for addressing any of these issues. Why do I care so much about this? Why is this a top story? This set of problems with Patent Center is causing a huge amount of time waste for practitioners and paralegals. There are tasks that used to take a minute, 2 minutes, are now taking 10, 15, 20 minutes because Patent Center has all kinds of problems that are slowing you down, kicking you out, making you log off, log back in maybe a couple of times, making you redo work that you've already done. Some of the common issues that we're seeing, one that I'm calling ghost sessions, where your browser loses sync with the server at Patent Center. It looks like you're logged on when you look in your browser, but you're not. And in fact, you can actually maybe navigate around a little bit in your browser and upload a document, and then suddenly you get kicked out. When you get kicked out, you very likely lose all of your progress. And so if you were conducting a lengthy transaction, you start over from scratch. That is very frustrating when it happens, and it happens frequently. There's also surprise logouts. This happens frequently. It possibly could have the same root cause as ghost sessions, not entirely sure. I've had surprise logouts happen when I've been logged in a long time, uploading a bunch of documents, filling out the forms for a patent application filing, and then suddenly I get kicked out. And all of that progress that I had gets lost. Even worse, I've had situations where I get a surprise logout right as I'm about to or after I hit the submit button for filing a paper with Patent Center, either filing an application, filing a response, or something like that, or when I'm trying to pay a fee. I had both of these things happen earlier this week. In one case, the document that I wasn't sure whether it got filed or not did get filed, but the fee that I was trying to pay, and when Patent Center crashed essentially in the middle of it, did not get paid. And I had to go back, and after hemming and hawing and trying to get back into Patent Center for about 10 or 15 minutes, I was able to get back in and determine the fee wasn't paid and pay the fee. But again, this is 10 or 15 minutes. That is something that never should have happened. I shouldn't be wasting time like this. And believe me, it's not just me. It's every practitioner I've talked to at this firm, where I work, and at any other firm. This is an endemic issue. On top of that, there's another subtle issue that you'll notice if you're in Patent Center for a long time. Maybe you've uploaded a bunch of documents to file for, 10 or 15 different applications, and you're going through each one at a time. You get through maybe 4 or 5 of those filings, and Patent Center starts getting really slow. Pages take a long time to load. It's not responsive. So eventually you log out, you log back in, and it's fast again. You do 4 or 5 more filings, and now it's slow again. So the longer you stay in Patent Center, the slower it gets. These issues are all easy to reproduce. I can reproduce any one of these every day. And yet we don't have a timeline for a fix, and we don't know what the Patent Office is trying to do about this. But it gets even worse. About 6 months ago, there was an assignment security data breach, and the PTO grayed out the assignment link for applications in Patent Center. They told us to use a separate assignment search portal, but it's not reliable. This search portal is not reliable. I know this because I've had situations where I've had a published patent application for which I know I filed an assignment because I have a notice of recordation for it. I look it up in the search portal and I get no result. In other words, I get a not found. So that would seem to indicate that the assignment was not filed, but it actually was filed, and I have proof that it was. So when you're trying to assess for a portfolio whether all the assignments have been filed, or maybe you're taking over a portfolio from some other attorneys, and you want to just go through and do a sanity check on it, you cannot rely on the results from the assignment search portal, unfortunately. Also, Patent Center file names are case sensitive. Why? Nobody knows. This doesn't make any sense. When I took Computer Science 101 many, many years ago, I was told, we were taught very clearly, even back then, never make anything case sensitive that doesn't have to be case sensitive. For some reason, you have to use lowercase when uploading files to Patent Center. And this to me makes absolutely no sense. It's 2025, guys. Let's get with the program. And finally, I don't want to turn this into a diatribe on DocX, but the Patent Center's DocX intake parser is extremely picky. And many of us have had to spend hours, literally hours, taking old Microsoft Word files and reworking them so that we could upload them as DocX files instead of PDFs. So let me just say to anybody from the Patent Office who's listening in, it's not our job to debug your software. You need to do better. Patent Center is not working. Somebody needs to take this and actually fix it. If you're going to be the source or the facilitator of American innovation, just get a website to work right. It's not rocket science, guys. Okay. So let me get off my soapbox for a minute here and talk about something that's, come on, AI, not controversial at all, right? Well, given what Don was talking about earlier with the new administration rescinding many of the executive orders from President Biden, we really don't know the status of the PTO's guidance on artificial intelligence that it published last year. It did publish 3 different guidances based on that executive order. Some of these, the points of these guidances will probably stand, others may not, but let's just take a look through them and refresh our memory. The guidance on AI inventorship, this is one that I think will stand because this was really determined by a case that went to the Federal Circuit, Thaler versus Vital, which stands for the notion that an AI system, even if it has a role in conceiving of an invention and reducing it to practice, cannot be named as an inventor on a patent application. However, only natural persons are inventors. However, if a natural person uses an AI system to assist that natural person in their inventive endeavors, that's fine, but the AI can't be listed as a co-inventor either. So you have to have at least one human inventor, but that human inventor can use AI tools to assist them. However, the Patent Office guidance does remind us that if you, the human inventor, only recognize a problem and then give a description of that problem to an AI system and ask it to solve the problem, whatever the AI system produces is not something that you invented. So in that particular scenario, if an AI actually comes up with an invention and you are not the inventor, the AI can't be listed as the inventor. That invention may effectively be unpatentable. And along those lines, just overseeing the operation of an AI system as it invents something, hypothetically, does not make one an inventor. There was also guidance on using AI-based tools. Here, the office acknowledges that examiners are already using AI tools for searching, which is not at all surprising. There are a number of points for practitioners, and whether or not this guidance really has any standing, meat to it. These are all pretty good, actually very good ideas that all practitioners should be aware of when they're using AI tools. Number one, Submit claims that are believed to be patentable. So if you're using AI to help you draft claims, make sure you review those claims. You edit them as possible so they're not overly broad. If you have an AI tool that's suggesting IDS references, make sure that those references are relevant and not cumulative. If you're using an AI tool to help you fill out forms, that's fine, but the practitioner's signature needs to be manually signed by the practitioner, just as in the situation when you're having a paralegal to fill out a form for you, the practitioner, need to actually sign it. AI tools can't be used to scrape the USPTO website. Instead, you can use the bulk download facility that they have. And also be careful not to disclose confidential client information to an untrusted tool. So if you are using a large language model that's based somewhere in the cloud, and you give it a bunch of information about your client's inventions, and that information is technically a trade secret at the point of drafting the application, just make sure that that AI tool has terms and conditions that will guarantee confidentiality. And if it doesn't, then don't use that tool for that particular purpose. So the bottom line here, to summarize, is that using AI doesn't relieve a practitioner of their legal or ethical duties or from the need for them to employ common sense. And finally, there was guidance on AI and subject matter eligibility. I was personally very disappointed by this guidance because it was almost totally non-substantive. It provided a few examples. Some of them weren't even AI related. And ultimately, let me sum it up by saying this. The USPTO's eligibility examples are tough enough as it is, because eligibility is effectively, and I know it when I see it, test. But the difference between what the USPTO purports to be eligible and non-eligible in these examples is incredibly thin. So you can take a claim, you look at it one way and it looks eligible, you turn your head 3 degrees to the right and you look at it again, it looks ineligible. I didn't find these further examples or guidance on AI and subject matter eligibility useful in practice. Just my opinion, but that's where I stand on that. So my advice to other people is don't really set a lot of store in this. 101 considerations are still art unit and examiner specific. So you need to work with your examiners who are actually reviewing claims and work through 101 issues with them. Okay. So Don and Kevin, we're going to need to get you back here. We've got about, I'm going to call it 10 minutes. And we're going to do what we call predictions. So last year, if you remember from our Top Stories of 2023 webinar, Don, Kevin, and I made predictions for 2024. So what we're going to do now is we're going to review those predictions. We're going to see, did we get things right? Did we get things wrong? Can we even make a decision? And then we're going to make some predictions for 2025. And as usual, since the three of us are not shy at all, some of our predictions are kind of out there, but that's the fun of the whole situation. So hey, Mike, let's start by Don.
Before you get to the recap of the last predictions, just 2 housekeeping notes. So if you have a problem getting the evaluation link at the end of the webinar, that a link will be included in the email that goes out to all attendees with the PDF copy of the PowerPoint. And also, if you had any issues submitting the CLE inquiries into the 2 poll questions, again, you can submit the response to clereporting@mbhb.com. So back to you, Mike.
Thanks, Don. Thanks for taking all the fun out of this part of the talk. I've been looking forward to this all week. All right, so let's go through our predictions for 2024. I made 3 predictions. Don made 1, and Kevin made 1. So as usual, I overperformed compared to those guys. My first prediction is that nothing of note changes in patent eligibility. I'm going to call this one correct for the simple reason that we had no Supreme Court 101 decisions. Nothing substantive, nothing new coming out of the Federal Circuit. It was just a handful of cases, pretty much run of the mill. No legislation got passed or really made a lot of progress at all. So and the Patent Office released guidance that really wasn't very helpful. So I'm going to call this one correct. And gentlemen, if you want to disagree, feel free.
No, I'll let you take one. In view of the other two conclusions, I'll let you have that one, Mike.
All right, fair enough.
You predicted nothing and nothing happened. Okay.
Yeah, no, this job is easy. So the next one, AI patent drafting and prosecution tools will proliferate and be widely used. I'm going to call this one mostly correct. There are a lot of AI patent drafting and prosecution tools out there, so I believe that they have proliferated. If you take a look at my spam email folder, I get solicitations from companies allegedly having these tools about every day. So if I had to guess, there's probably a couple dozen companies that claim to have these tools. Whether they actually work or anything beyond just a thin wrapper around Gemini or ChatGPT, who knows? I don't know how widely used they are. I suspect that they're going to be widely used soon because they are maturing, but I don't know if they're widely used at this point. I don't know if there's any way to really survey that information. So I'm going to call this prediction mostly correct.
Hey, Mike, on that prediction, the thing that always concerns me is security. And so they may be available, but I get a little bit nervous about where that information is going, if it is contained. So that's my concern.
Yeah, I think eventually whatever drafting tools you use, whether it's Microsoft Word, Google Docs, or what have you, it's going to be just built into those tools. So I think ultimately, whether these third-party tools get bought and used, I think we're all going to be using them by default anyway in the tools that we already have. All right, next. An invention co-created by AI will be issued as a patent in 2024. This is my go out on a limb prediction. I don't know if there's any way to really verify this. I wouldn't be surprised if it's true. I wouldn't be surprised if it's not true. So I'm going to call this one kind of a gray area. And, if you guys want to tell me that I'm wrong on this one, I guess I'll take the hit on that.
I don't think there's any way of knowing.
No.
So
okay.
I would stick with unknown.
All right, so I'll give myself 1.5 points out of 3 here. Then Don made a very, very risky prediction that EPO's unitary patents will increase in acceptance. I mean, how can this not be true? But feel free to elaborate, Dr. Zuhn.
I like to have safe predictions. And so it seems like it's being accepted. It took a while for European patent applications to garner acceptance. And so I think in a couple of years, this will be the way to go. I have clients who go after unitary patents, and I have a lot of clients that don't. And so it really depends on the client.
Okay. Yeah, I mean, anecdotally, I would tend to agree that they are increasing in acceptance, but the rate of increase, I'm not quite sure what it is. All right, moving right along. Kevin predicted that Chevron deference would be reduced, but not eliminated. So I don't think this is just wrong. I think this is actually very wrong. Chevron deference is gone, as far as I can tell. And however, that probably has very little impact on patent law because the courts never really gave much deference to the patent office anyway. But that's my opinion, Kevin. Feel free.
Well, no, I would not disagree with you. I would just say in my own defense that you can't be brave enough to be right if you're not brave enough to be wrong. So, I took a middle position, but the court did what the court did. The court surprised me before. I'm sure the court will surprise me again. But whether that turns out to be the right decision, I think we'll find out. And the only thing I'd say about the patent office is that the thing that they have going for them is that they get deference on the facts, right? And this didn't apply to the facts anyway. In fact, many of the arguments about how this was a really bad decision talk about this particular expertise that the different administrative agencies have. To the extent that we kind of have a Zerko application to more than just the patent office, probably won't have that much of an effect, but it will have an effect. And I don't think it'll have as good an effect as Justice Gorsuch thinks, or as bad an effect as Justice Kagan thinks. But yeah, it's a change.
Okay.
I've said before in print that Supreme Court is not a stare decisis court. The Supreme Court is the court that changes things when it thinks it should change. And if you go back in history and think about the things that have changed due to Supreme Court decisions, I think that you probably agree. So, okay, it went this way. We'll see what happens going forward.
And for what it's worth, if I had to make a prediction about Chevron deference in early 2024, I would have made the same prediction and I would have been just as wrong. So that's fair. Also, I made a New Year's resolution just verbally right at the end of our predictions last year. I said that I would write more for patent docs, and I did not do that. In fact, I wrote less for patent docs. So I'm going to try to do better in 2025, but we'll see. All right, predictions for 2025. I've only got two, both focusing on the USPTO, since I spent a lot of time thinking about the USPTO when preparing these slides. My first prediction, and this is more of a wish list item than a prediction, is that the PTO fixes Patent Center, or at the very least makes it less bad. I don't have a lot of confidence in this, but that's nonetheless something I'd like to see happen. I think it's likely that it'll happen now that we have a new administration. Maybe they'll be willing to fix the errors of the old administration, and they can always blame it on Biden because they can. The second prediction that I've got, this is the go out on a limb prediction. It's kind of a crazy idea, but it goes as follows. We have an executive branch that seems to believe it has powers to do things like nullify parts of the Constitution or overturn the Supreme Court through executive order. So the USPTO, as part of that executive branch, will determine that the Federal Circuit has interpreted Alice versus CLS Bank far too broadly, or the exceptions of Alice versus CLS Bank far too broadly, and decides that the USPTO now believes that the Alice case means that financial transactions are probably ineligible, but has no impact on any other type of technology. Again, this is me going out on a limb here, maybe a bit of a wish list too, but the USPTO goes to war with the Federal Circuit. All right, Don, you're up.
Yeah, I'm going to do this pretty quickly because we're a little bit past time. We should be wrapping up at about 11:20 a.m. Central Time, no later than that. So I think because the hiring freeze order, we're going to see a reduced examining corps, and therefore application pendency will increase slightly, not too much. I think Congress is going to again introduce a patent eligibility bill. Let's see, and I said introduces, not pass. Let's see where that goes. And I do think that the Trump administration is going to reject any international IP waivers. So, Kevin, you're up.
Yeah, I can do this really quickly. I have three predictions and three wish lists. I think, granted, Don would disagree with me, I still think that the pressure, and the word list is missing in that sentence, that the pressure of drug prices will continue to have the FTC to do its crusade against improperly listed Orange Book patents, the devices based on the Teva Amneal case. I do think that one way or the other, you're going to have the margin rights going to be maybe limited, but are going to be used. And I think that, as Don has said, the backlog will increase because the working examiners will quit. I hope Congress codifies ODP and narrows it to just alienation prohibition. I think that the PTO could actually give guidance on the one-on-one rejections faster than we get anything out of Congress. And I fervently hope that the Federal Circuit reinstates Judge Noonan. So those are my predictions and my hopes.
All right. So thanks, everyone, for sticking with us a little bit extra long this time. This is our contact information. If you have any questions or you just want to reach out, shoot us an email. We're always happy to hear from you. Thank you very much and have a wonderful day.
Bye-bye, everybody.
Thank you.